Welcome to Winning Isn't Easy. I'm Nancy Cavey. I am a nationwide individual disability and ERISA disability attorney. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I've got to tell you that. So now that I've done that, nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers or plans play, and what you need to know to get the disability benefits you deserve. So off we go. Today, I'm going to be talking about Sedgwick. Now, I've talked about Sedgwick once before, but what can I say? When carriers or servicing agents don't do what they need to do, they're the subject of litigation. So let's talk about Sedgwick once again. Now, they were once a very large British insurance broker who were bought out by Marsh McLellan in 1998. And they are, among other things, a risk management company. And what that means is that they were helping to manage risk. And that can be done in a way that minimizes the expenses or exposure of an employer or a carrier or a plan. Get the hint here? Now, Sedgwick is also a third-party administrator of disability claims. What does that mean? That means that the employer has set up a disability plan and they've hired a third party to administer the claim. Now, if you aren't doubting me, go and Google Sedgwick. And what you're going to see is their disability and absence management page. They brag about the Sedgwick difference. And that's not a difference that is good for you as a policyholder or a plan beneficiary. Now, what they brag about is how they manage absences for the benefit of the employer and not the disabled plan participant, despite what they say on their site. And again, if you don't believe me, I would suggest you just Google complaints about Sedgwick. What I'm going to be doing today is going through an overview of Sedgwick by examining a number of cases. These cases have different stories, different origins, and different interactions with Sedgwick. But the common thread, I think, are the lessons that you can learn about how Sedgwick, as the third-party administrator, handles claims. Now, what we talk about today is also applicable, in my view, about how disability carriers and plans handle these claims. It's not necessarily unique to Sedgwick, but Sedgwick has a few twists that we'll talk about. Got it? So we're going to talk about 5 things today, and I'm going to be telling stories. I'm going to tell 5 different stories about different people who had claims that were involved with Sedgwick. So I guess this is going to be the story time version of Sedgwick. Got it? Let's take a break for a moment before we get started with my storytelling. Welcome back to Winning Isn't Easy. I'm going to tell you about the story of Miss Foster and her dealings with Sedgwick. Now, she was sort of a beneficiary, if you will, of a short and long-term disability plan that had been created by SunTrust. This was administered by Sedgwick. SunTrust short-term disability benefits were paid from SunTrust general assets and required objective medical evidence of disability. So in other words, any benefits were paid out of the pocket of SunTrust, her employer. Now, ultimately, what happened was that her claim for short and long-term disability benefits were denied, and this case ended up in federal court under the ERISA statute. SunTrust, however, argued that the short-term disability plan was exempt from ERISA since it was a plan that was paid for by the general assets of the employer and was entirely separate from an employee benefit plan. Now, the court agreed and found that ultimately it was a payroll practice, which was exempt from ERISA. Now, normally that's a good thing because ERISA is not necessarily a friendly place for a disabled plan beneficiary or policyholder to be. It's really slanted, I think, in terms of the benefit of the disability insurance carrier or the plan. And one of the things that you'll see is that every circuit in the United States, and there are 11 plus the District of Columbia, have their own way of interpreting the ERISA statute. So that means that there are potentially 12 different ways that this statute can be applied. And it is applied differently in different districts. In this case, because it was not an ERISA plan, the judge was able to look at what they did. What did Sedgwick do in administering the plan? And unfortunately, the court upheld the denial of the claim on the basis that there wasn't objective medical evidence as required by the terms of the plan or the policy. And ultimately, of course, this can make it difficult for you to get the disability benefits you deserve. One of the things I always want to do from the very beginning when a person consults with me about filing a disability application for them or to file an appeal of a denied claim is to look at that policy or plan to see exactly what it is the proof is. You, the policyholder or the plan beneficiary, have the burden to prove whatever the policy or plan requires you to prove. Generally, you have to prove that you are disabled, as that term is defined, and it could be defined as the inability to do the material and substantial duties of your own occupation. It also could require objective evidence. For example, the FedEx plan requires objective evidence. And in that instance, the FedEx, or in this case, SunTrust, is going to have their administrator look at the medical evidence and determine whether or not there is one, objective evidence, and then two, whether or not that objective evidence proves that the plan beneficiary meets the standard of disability. So the terms of the policy or the plan can make all the difference. And in this case, the court agreed with both how SunTrust and Sedgwick handled the claim. Got it? Key here is let's look at the policy or plan and determine, one, whether or not it's covered by ERISA, and then two, look at what the policy plan or the policy or plan provisions say about the definition of disability and what you have to prove to get the disability benefits you deserve. Got it? Let's take a quick break.